Larson. And this is on for presentation of the proposed order. Sounds like I received two primary objections to the proposed order. If we want to go through those, is that correct?
That's correct, Your Honor.
Okay. So let me just jump into that digital file here. Number one on the temporary parenting plan, section 5A. This is the extracurricular activities, which sounds like there's some crossover with an objection to the shared expenses, extracurricular activities on the temporary child support order. But for the parenting plan, it sounds to me like the objection is meaning Mr. Ryan Larson, wants that to be joint versus limited. Is that correct?
That's correct, Your Honor. Either way, Mr. Larson needs to have a say in the extracurricular activities because he will be the person who has to pay for them. And we need to make sure that he can perhaps have a say in anything involving an expense.
Ms. McLean, what is your client's position?
Your Honor, my client's position is that the child has historically been involved in various extracurricular activities, including currently Taekwondo. That was one of the items that was outlined in the declarations by the parties and the text messages. She's also done gymnastics and swim lessons in the past. And my client has been interested in involving the child in dance. This was not something that was argued at the time of the motion. We did argue specific provisions of the decision making where originally you had indicated that those would be all my clients. So you later changed your ruling relative to that in regards to education, religious, and non-emergency health care. So I think that this is quite frankly an attempt to try and re-argue those issues. If the court's inclined to make any changes, given the fact that Mr. Larson lives up north and works full-time, he's several hours away. My client has the child full-time, particularly during the school week, which is when these typically occur, although I think that there have also been some, particularly with Taekwondo, I think there have been activities that have occurred on the weekends. I would suggest if the court is going to make any type of changes that you maintain the sole decision-making, but that if it exceeds a certain threshold, let's say if it exceeds $150 per month, then she would need to seek his approval.
Ms. Margraf, your position on dollar amount limitation triggering his approval.
Would that include what's already being paid right now for the Taekwondo? Is my question. I think the essential issue here is that Mr. Larson is at capacity with his budget and has to be very careful about anything added on top of what he's already paying for.
What is do you know what the cost of the Taekwondo right now is?
I don't know, but my client's online. If the court would be willing to allow her to just pipe in with that information, I'd appreciate it.
Yes, I think that would be helpful. I like the idea. I mean, I am going to stick with my original decision that Ms. Larson would be the primary on extracurriculars, but I do like the proposal. I think it's fair to put a dollar limit on it that would trigger Mr. Larson's agreement. So Ms. Larson, I think it would be important if you can hear the court to give us some input on what the current cost per month of the Taekwondo is.
Yes, ma'am. Taekwondo is currently $60 a month, and then there are some occasional additional fees as to testing, which is, it varies based on the belt that she gets. So every 3 months, she'll do a testing. This next testing will be about $40 for her new belt. And then she also has, currently for her current belt, she has a cost of $75 for USTF membership dues so that she can get her next belt.
Okay. And how often would you be I'm sorry, go ahead, Ms. McLean, sorry.
I was just going to ask a clarifying question. Are the dues annual or are they related specifically to the belt?
It is annual. The 75 is annual.
Okay. Sorry, thanks.
Yeah, so I'm just going to pull out a calculator here. And the $40 would be every 3 months?
Yes, yes, every 4 months.
Every 4
But
months.
No, it's 4 times a year, every 3 months.
Okay.
And it increases per belt. So her next belt's 40, the belt after that is 45, the belt after that is 50.
Okay.
So the increase by 5 per belt.
Okay, and then let me just get a basic understanding of the additional things that you're wanting to add for extracurricular. Might be gym, swim, dance. Do you know?
I would just say swim for now, ma'am. And then, as she's very interested in getting swimming lessons, and I'm very interested in having her be able to swim. So that would probably be the only one to consider currently, like seriously, whereas the dance and gymnastics, I'm still looking for a place that would be suitable, but the swim is definitely high up there.
Okay. Do you know how much that is per month? Just approximately.
Yes, ma'am. The whole course for swim, it was 45 if we did the high school that she used to go to, 45 per session, and every session is 2 weeks long.
Okay. So potentially 90 a month.
Yes, ma'am.
Okay. That would put us at the 150 without even adding on the additional belt fee. So here's going to be my proposal. If the parties want to disagree with it, we can hear argument on it. But my thought is we keep Ms. Larson as primary on extracurricular, but we write in that anything beyond swim and taekwondo would require input from father. Agreement by father. Because it sounds like those two things together would hit that 150 a month.
I'm fine with that, if the court wants to interlineate that.
Okay. Do you I have the order here. I believe.
So it would be in the parenting plan on page 3.
Okay. And then the other on the temporary child support order, section 5, does this parent have income from overtime or a second job? And it looks like maybe that's just a clerical error and we need to change that to no. Is that correct?
We believe so, Your Honor.
And I would argue against that. Again, if you go back to his wage stubs, he doesn't have just a straight salary. He has essentially an hourly plus overtime, plus he has sales incentives. So in other words, if you were to consider only his hourly amount, then his gross would be about $4,999 a month. You set a gross of $6,868 per month, which included his sales incentives, which are secondary checks that he receives. So if we don't identify that that additional income is included, I think that that is contrary to what your findings were.
I see it. I think I was just looking at it from the standpoint of, does this parent, so the second job, we know he does. So I think we should clarify no second job to make it very clear on the record. And then
and this is basically boilerplate language
yeah.
that the pattern forms require. So, and it's a disjunctive, it is or. So I was relying upon the overtime.
Your Honor, that's no longer the case. There was maybe an interim pay stub that reflected half of what was going on before, and then the transition to salary only. At this point, it's been at least 2 months where Mr. Larson has only received salary. Any kind of incentive pay is still lumped under the general rubric of income under the statute. So we would ask that that be changed to no, he does not have a second job.
If I'm just, yeah, let me look at, let me just go back. I want to re-review his pay stub.
That was filed on July 6th.
Yeah, I think the question is just whether it classifies as overtime, because like you said, these are boilerplate forms. And if it's not technically overtime and it's not a second job, I would leave it, or I would put it as no. So historically there was overtime, but let me go to the most recent pay stub we have for now.
If you look at the June 21-23 pay stub, that still shows his sales income or sales incentive overtime and sales incentive, which is continuing even though he started this new position in May. And then if you switch to I think it's the last pay stub in that packet dated June 23, then that shows his regular pay. So he receives 2 different sets of checks each month. Actually, he receives 4 sets of checks each month, or it could be 6 sets if there's 3 pay periods in a month.
Yeah.
Regardless, that's just a carryover from when he was still a salaried employee. These incentive checks do not come with any necessary regularity.
The last one in this packet is March.
Are you looking at the July? Oh, maybe. Well, I received them with the March pay stub as the first page under the sealed financial source, and the June 23rd as the last filing in that field financial source document.
Okay.
So you should have a June 21, which is the sales incentives, and the June 23rd, which is his regular pay.
Yeah, I know we looked at all of these during the hearing, and I'm just not finding that June pay stub in this packet. There was a pay stubs for respondent filed on June 2nd, 2023. There's about 200 pages. Is it in that?
I don't believe so, because I'm looking at the ones that were filed on July 6th.
Those are the ones we have, Your Honor.
I don't have
For
anything.
more recent information.
Say that again.
We submitted them for more recent information about his pay.
Okay, what date did you submit that?
July 6th.
Okay, let me get back up there. So what I am seeing is he did have overtime in April, not April. He had overtime in the April 14th paycheck. He had overtime in the March 31st pay stub. He did not have overtime on the April 19.
Actually, he did. He had sales income overtime of
Well, sales, right? He has sales incentive, but I'm think the boilerplate language is just overtime. So,
the OT is considered overtime.
oh, the sales incentive OT, I see that. Yep, you are correct. Then we have April 28 paycheck. There's no sales incentive overtime, but there is regular overtime. Then on May 12th, he has overtime, no sales incentive overtime. He has sales incentive overtime on May 17, but not regular overtime. On May 26th, he has no overtime, no sales overtime. Same on June 9. But on June 21, 2023, he does have sales incentive overtime. So I think it is incorrect to say when we were averaging his wages that we weren't taking into account overtime. So I believe the language there is appropriate. So I'll leave that as is. Section 22B, other shared expenses, extracurricular activities. Is this still an issue the parties want to argue based on how we ruled on the kind of the extracurricular threshold for decision making? Is this still an objection?
I think we feel there's sufficient protection with the language from the previous section.
Yeah, I think that makes sense. Okay. Any other objections we need to cover? Otherwise, it sounds like what I'll be doing is interlineating our extracurricular threshold that would trigger the agreed decision making, and then otherwise sign that and get it filed with the court. I have
Thank you
Ms.
very much, Your Honor.
Anderson,
Leave us at, Your Honor.
pro
Thank you.
se
Okay,
on
thank
that
you both so
matter. I do see Mr. Einerson here represented by Ms. Bash. Let me just get into the digital file on that case. All right. So I have received, and I do have an original of both the temporary family law order and the parenting plan that Ms. Bash presented to this court. I am also in receipt of the objection, Ms. Anderson, that you filed. So let's go through that. I have gone back and reviewed my notes from this previous case when we were all together on June 25th.
Actually, Your Honor, we were here before the court on July 11th.
Yes.
We were to do presentation of orders the
Great.
25th of July, but it was
I'm looking at July 25th when you went in front of Judge Bassett and she said this. So yes. All right. So Ms. Anderson, it sounds like we'll start off with what I view kind of as your primary issue with this, which to me appears to be the holiday schedule. Is that correct?
Right. When we had talked to you, I believe you said we were going to adopt mom's plan with some changes. And so the holiday schedule was very different between his parenting plan and mine. And when I emailed his lawyer back, she said, that's not what the commissioner meant. And I didn't object at the time of the hearing because I didn't think you were using their plan. So I was confused and not sure what was supposed to be the case.
Yeah. So Ms. Bash, tell me what prompted the holiday schedule on page 8 and 9 and kind of flowing into 10 that you presented to the court.
Absolutely. So, Your Honor, when we were back before this court on July 11th, the court adopted mom's timeframes as far as when the parents would exchange. This court would remember there was no restrictions, no limitations on parenting time for either parent. And the court's main concern was making sure that everything was maintained as routine as possible for the children, for a plan that the parents had supposedly followed since they informally mediated this and came up with this 50-50 time split back in March, obviously before this was filed with the court. And so the court agreed that let's keep this routine because the court's concern was making sure that this was as normal as possible for the children, or at least what the parents had been following for the most part, not really, but for the most part, for a couple of months before it became before this court. When the court ordered that, the court then asked, so the court ordered, yes, we're going to follow mom's proposal as far as parenting time. And then the court moved into, okay, how about the holiday schedule? When the court mentioned holiday schedule, mom's response was, I don't care about holidays, which I thought was interesting because I actually wrote that verbatim down in my notes. I've never had a parent that responded that quickly and with that remark. What I stated to the court was,
Ms. Anderson, I'll come to you. Don't worry, I'll get your side.
so what I said is, I don't believe there is much difference in the holiday schedule. And so I don't think that there's going to be any concerns. When I was preparing the temporary order, when I went through, it is not significantly different. Quite frankly, 80 to 85% of between the proposal of both parents, the holidays were fine. The only difference being that when it comes to Memorial Day, 4th of July, and Labor Day, those particular holidays are very, very important to, pardon me, my assistant left his phone on. So those holidays tend to be very, very important to Mr. Einerson and the children. He typically has some sort of plans with them, camping, fun activities during those particular holidays. And it's my understanding historically that he was able to do this. Mom may or may not have really participated in the past. And this also gave her kind of a break, which I'm not going to knock Ms. Anderson for wanting a break from the kids and having dad take those activities, which is why we adopted that particular holiday schedule, in that it had not been fully addressed. And in that mom doesn't particularly care about the holidays. This is not by any stretch of the imagination to get some sort of leg up for dad to have more time with the kids. It's just a matter of those are the important holidays for him. The other section that we had initially in our proposal, and then Ms. Anderson also had in her proposal as well under section 10, where we're talking about when you get to the end of the major holidays, there were other occasions. And so there has been this concept about dad's military training and what he's going to be able to be doing, and whether mom would be the primary parent, or not primary parent necessarily, but she would have the first right of refusal if his training time should fall on his parenting time. So it's my understanding from my client, and as this board, if you've read the other declarations that we have provided and filed with this matter, dad has decided that he is now going to end his military career. He's either going to retire or he's going to go into inactive status. Either way, of the one training that we know of that he will have in September, it is day only, and it doesn't even fall on his parenting time. So it's a moot point. We don't even need to add that particular section in here anymore, because dad has worked with his superiors and ensured that if there is any kind of required training, that he A, won't have to go overnights, and B, it doesn't even fall on his parenting time anyway. So the kids are already with mom. So that's the reason why we completely eliminated that in our proposal. So those were the holidays were the main difference, and the military issue. The other issue that mom has brought up, just for the court to be aware, because we have to go before holidays, when we're talking about parenting time, mom had proposed in her initial proposal that during the summers, starting when school gets out, that they somehow go to a week on, week off parenting time schedule. That was not addressed by the court on the 11th. It wasn't brought up at all during the hearing on the 11th. And the court was very clear again. We want to keep this as routine as possible while we're going through this process. And so here we sit on August 1st with only approximately 3.5, maybe 4 weeks left of summer vacation. It doesn't stand to reason that we would break from that routine for just a couple of weeks and basically defy what the court was trying to do, which was let's keep this as non-stressful for the kids as possible. So that's why that particular section is not in there. And we just adopted, as the court had ordered, that we continue the regular schedule even throughout the summertime when the kids, well, Theo is out of school, and then we've got 2 other littles that have preschool. So that's the reason for that particular piece. I am also understanding, I don't have, so the court is aware, I don't have specific objections from Ms. Anderson. What I did receive very, very late last Thursday evening was her proposed temporary parenting plan and her proposed parenting plan order, which she wants to change now the court's very specific order on transportation for the children when they have sporting activities. She completely eliminates the language about parents not talking disparagingly about each other or talking about the case with the children. That's removed in both her temporary order and her parenting plan. The court was very clear that that needed to be in there, that was important so that we make sure that the children are not inadvertently dragged into, adult topics and this whole mess. And as far as telephone calls, just so the court is aware, so we can kind of hit this all at once, the court had initially thought that maybe phone calls between the parents and the children when they're at other respective times, or parenting time with the parents, would be between, say, 6 and 7 p.m. In response to that, the court also said, hey, if that doesn't work for the parties, please, work out some sort of time. I did receive an email from Ms. Anderson, which she said, hey, can we do 6:30 to 7:30? I ran that by my client, and according to my client, bedtime routine is pretty routine in his household. Children are in bed by 8. And so I asked him, okay, theoretically, on average, how long does it take to get through bath time, story time, song time, potty time, whatever we need to do to get the kids down? And he said it's about 45 minutes. So what I suggested is that we do 6:15 to 7:15, where a parent, mom can call dad, or dad can call mom, either way. And then that parent has at least 45 minutes to do the normal bedtime routine. And so that was our suggestion. I don't have a specific objection from Ms. Anderson, so looking in her latest parenting plan, she's saying that now she wants phone calls to be at 7. And so I think that that's going to be putting the kids late. Either way, it's going to put on the parent, whichever parent has the parenting time at the time where the other parent is calling. It's going to throw off their schedule. It's going to throw off the kid's schedule. So at this point in time, given that the differences, I believe, and what I have prepared for the court accurately reflects this court's order from July 11th, I respectfully ask that the court adopt the parenting plan that I have provided, as well as the temporary order that we have also provided to the court.
Ms. Anderson, I'm going to hear from you in just a minute on some of these items, but I'm just first going to address Memorial Day and July 4th. I find the argument that Mr. Einerson is the only one who cares about those holidays, even without hearing from Ms. Anderson. No, he's not getting those two holidays every year without Ms. Anderson ever getting her kids on the 4th of July or Memorial. I did not take her statement that she wasn't as concerned about the holiday schedule to mean that she didn't care about those holidays. So she will be getting those every other year. I'm a little bit floored by that argument that only one parent cares about a holiday. So in looking at what you all have done with other holiday schedules, I think her proposal in her original order, just going to flip to that, which was much more equitable, was that odd years would be with her and then even years would be with him. So I'm inclined to adopt that unless the parties want to agree that that should be switched to even years with Ms. Anderson. Okay, I'm going to go, hearing no objection, I'm going to go ahead and write in the original proposal.
I was just writing down in my notes, Your Honor, I apologize. So if we are looking at this and in the proposal, is mom suggesting I'd have to go back and look at hers, that for Memorial Day, 4th of July and Labor Day, she's saying every year odd years is with her and every year even years are with dad? Even years with dad, odd years with her.
And I don't care if we switch, so some are even, some are odd. I just would like them every other year. So if we want to go back and forth and do one even, one odd, I just wanted to make it less complicated with.
Do you want to do odd years? So we'll start with Memorial Day. That's the first one. So let's just, before I write this into the final order here, the temporary order, but the final temporary, odd years with Ms. Anderson for Memorial Day. 4th of July would be odd years with Mr. Einerson. And then the other one you had listed for just him was Labor Day. Whether the parties want that to be odd or even with Ms. Anderson, I'll let the two of you decide.
Odd or even at this point, should I suggest a Labor Day typically, although I know that school districts are changing this around a little bit and trying to start school early, is the court more inclined to have that particular language be with whoever has the parenting time before school starts? So we start that, so the kids are with the parent. I don't think it would really matter because we're not changing schools or anything for the kids. And so either way, parents are going to have to get the kids to school, but I guess I'll leave it to the court's discretion.
If Ms. Anderson, if you two are in agreement on that?
I mean, it's just,
hold on one second. If you two are in agreement, fine. Otherwise, because it is a technical holiday, I know a lot of people go out of town for that holiday, camping trips, etc. I would prefer to have that be alternating, just like all the other holidays. But
well, especially since we technically split weekends, that, I mean, we could argue either of us have that weekend. So that's kind of up in the air. So I would prefer it's every other year.
Okay. So hold on, I'm just making these changes. So odd years for Memorial will be with Ms. Anderson. Odd years, 4th of July, Einerson. Labor Day, I'm taking out every year with Mr. Einerson. That will also be alternating. And we'll go odd years, Ms. Anderson.
If I was going to say, if Dennis already has plans for this Labor Day, since it's a month from now, we can discuss if he's already have plans.
Well, I mean, we could just put him in for odd years then, and your Labor Day will start next year. Why don't we do that?
That'd be good.
I think that took care of the 3 differences in the holidays. I'll briefly address the other occasions important to family on page 10. That is one where I saw mother's proposal had the language in about father's military service days. I am not inclined to add that language from Ms. Anderson, your proposal. It sounds like we could craft an order, I guess, that could potentially foreshadow every possible circumstance the family will go through. It sounds like military service where kiddos would be with him, but instead need to be with you is either not going to happen at all or be one more time this year. So I'm not going to include that in the order.
So what happens if he does not retire and it does become a problem? Do we come
Well,
back?
this is a temporary parenting plan. So you all are going to be either going to mediation or a trial to agree on your permanent parenting plan. Please bring that up if it doesn't seem like what is being said today in court is what actually happens. Okay. I am going to leave in, and Ms. Anderson, I will let you speak. I know I kind of took over here, but I'm going to leave in the transportation that I had already discussed in my original ruling. I absolutely am going to leave in the both parties need to refrain from disparaging remarks, gestures regarding the other parent. You shouldn't be discussing this court proceeding or adult topics with the children at any time. That's fairly boilerplate language and also very important with younger kiddos. The telephone call time, I see in the proposed order 6:15 to 7:15 now. Ms. Anderson, why don't you tell me a little bit about why that isn't agreeable to you?
Well, I've just noticed in the last few weeks since we've talked to you that he tends to have the kids out and at other people's houses, and he doesn't have service and they're busy or they're eating at somebody else's houses. So I figured if it's at a specific time, they can be home getting ready for bed. Because I mean, I finally got a hold of them at maybe 7:30 the other day and they hadn't eaten and they were at his stepmom's house with no service. So I just figured, having it at a set time, because they aren't going to bed before 7:15 generally, that if we could do that, it would be easier for the kids.
Okay. And so, I mean, Ms. Bash, I understand your argument. I think setting this hour where both parents know the phone call needs to be made or is being received makes a lot of sense. I do want to add some language though, because I certainly take into account Ms. Anderson, kind of the thought behind your argument, which is, well, what if they aren't available during that hour? Does that just mean the parent doesn't get to talk to them? So I do think we need to agree on some language that indicates that if that hour doesn't work out, the child should be permitted to call the non-residential parent before bed.
I think that's fair. I think that we can make sure that if there is a set time that parents both need to ensure that the children are available or in a place where they have service.
Yeah.
It's just something that we need to make sure that ensures happens. If at any point, for whatever reason, it's going to be missed, I don't mind even adding language like the parent needs to inform the other parent, like, hey, we're running back from a baseball game or something, and it'll be available at a certain time. And so that phone call can be made, and then the kids can call the parent as soon as they're home. But as close as the parents can possibly do this during a certain time. So it's not a consistent, oh, great, this is, changing all the time. Because once again, keeping this as routine for small children is critical.
Ms. Anderson, go ahead.
I'm not sure. I mean, generally it's his phone calls that aren't going through very well with trying to call my kids. So as long as he can be home and have service, then that's fine for me. I mean, I did ask for the time to be changed because when I don't have the kids, I generally am closing my store and that's at 7:00. So that's kind of also why I went by 7:00 because I can close the store and call the kids. And
I gotcha. Okay. So if the time is 6:15 to 7:15, does that effectively just leave you 15 minutes?
Basically, yes. So I can call them once I close the store, or I have to call while I'm working. That's why I figured 7:00, and that way it's before bedtime, and hopefully they're home getting relatively ready for bed anyway.
Yeah. I mean, that does, Ms. Bash, that does raise some concerns for me. I certainly don't want to put a parent in a position of having to both be working and making their phone call. It does sound like, well, when we originally talked about this, we set 6 to 7 p.m., which would cause the same issue for you.
Right. That's why I had emailed, actually, I had messaged Dennis and asked him if he could ask his lawyer to write in 6:30 to 7:30, and he didn't agree with it.
Okay.
6:30 to 7:30 still affects mom's work schedule if she's closing at 7. And so,
well, at least it gives her either the option to get off work a little bit early, or she gets 7 to 7:30, which is a good half an hour period. So I think 6:30 to 7:30 strikes an appropriate balance between dad's concerns and mom's schedule. So I'll go ahead and change that.
Thank you.
That's not a huge difference for you all. I'll initial that change. Okay, that was on my list. Those were the items on my list for disagreement. Ms. Anderson, what have I missed?
I had asked, and I didn't mean it needed to happen this summer, since obviously we are almost done with summer, but I would really like the kids to go on it every other week in the summer, because we've had issues to where Dennis and I were in agreement that Theo could do some camps. There's a horse camp and down the street from my house, but he went back and said, I'm not going to bring him and you can't have him extra days. And so I think with being a week on, a week off, I could sign him up for camps. Dennis could also sign him up for sports camps and things like that in his area on his weeks.
So, Your Honor, at this point, I think we just should adopt as well that this is just a temporary plan, that we remove the, well, I don't even have it in the proposed order if that's what the court is working off of. We remove it for this year, if Ms. Anderson is fine with that. And knowing that, as this court mentioned multiple times on the 11th, this is just a temporary plan. If this needs to be addressed in a later plan or a final plan going down the road, then certainly we can address it later, but I don't see what really applies this right now.
Yeah, and here's what I'll write in. I'm just going to state for this temporary plan, and again, given we're about 3.5 weeks from school starting or so, I'm going to leave it as is, but I'm just going to write in next to number 9, where you have checked the summer schedule is same as school schedule, and I'll just put reserve. I think this goes without saying, but just this will tell whatever judicial officer hears the ultimate resolution of your case. Reserve final summer schedule for trial/resolution.
And just so the court's aware, it's my understanding for right this moment as we sit here, I think that we are assigned to Judge Fassett as the judicial officer going forward. I know that's subject to change. But for right this second, that's what it looks like.
Okay, perfect. So I think that'll just be my little clue to the judicial officer that it was an issue that came up in the temporary parenting plan. I'm sure she'll see from the timing of when we entered this, why we did it this way. If you were here in front of me in June 1st or May 1st, I think we may want to reconsider this. I think it makes sense. So typically what this court would do, I think, especially in permanent parenting plans, is make sure that each parent has at least one full week with kiddo straight through the summer, so you can do those vacations. So I think
I anticipate that, Your Honor, going forward. I think that we're going to be able to, look at typically boilerplate language I do with other clients. It's like somebody by, May 1st, they need to let the other parent know respectively if they want, but that's not really something that needs to be in this right now.
I agree with that. So Ms. Anderson, anything else you want to?
The paperwork I just sent you, I changed the Christmas schedule because I realized the discrepancy in what we had each filed. I was going to get the kids for, I believe, 11 hours on Christmas Eve, and he was going to have them for like 36 hours straight. And then we were going to go back and forth to the regular schedule. And that seemed a little unequal and a lot of transporting back and forth with the kids over holidays. So I switched it to first half, second half of Christmas vacation, and then to switch, first and second each year, I believe. I thought that would be easier. It's only, I believe, 2.5 weeks over Christmas. So it's not a large amount of time. It's about a week-ish each parent over Christmas break. And, up until I think it was New Year's Eve day.
I think what you sent me, so what we have in Ms. Bash's proposal is Christmas Eve will be with respondent, you, Ms. Anderson, every year 8 to 7. And then Christmas Day would be with petitioner every year 7 p.m. to 8 a.m.
That's until the 26th.
Yeah, I see that.
For a large amount of time. And I realized how unequal that was. And that's why I changed it in the plan I had come up with to object.
So this reflects exactly what the initial proposal that have been provided really by both parties, which is one of those holidays that they agreed on, actually. So
that was at the time that the petitioner was being fairly civil. So I was okay with it. And then I realized going through the paperwork how unfair and a lot of switching back of the kids that week it was going to be between the regular schedule and the holiday schedule and then back to the regular schedule.
I believe this also reflects, and if I'm wrong, I'm wrong, but I believe this also reflects exactly what had been mediated between the parties informally before. And so for now, I would argue that we keep it as is. This was something that was considered before instead of adding things kind of at last minute, because I'm not getting things timely from Ms. Anderson. And so getting documentation just, the night before we're supposed to be before Your Honor isn't helpful. And I certainly don't have time to discuss that with my client to see what his take is. So at this point, I don't mind if the court wants to reserve to have this issue argued at a later date as we get closer to the Christmas holiday. But for right now, I don't have an opportunity to discuss this with my client.
Yeah,
Okay, so-
and I'm just looking at your original proposal, and it does, Ms. Anderson, match with your proposal, but because I think we do have a few months before, well, not I think, we do actually have a few months before Christmas. Why don't I go ahead and reserve on that? If you want to note that sole issue for a motion docket, I do think that makes sense. I know those holiday breaks are very important to both parents. I do see the discrepancy in the amount of time with each parent. So I am just going to cross this out for now. For now, what I'm going to do is put, just as a placeholder, we're going to trying to think what makes the most sense.
And I did email that paperwork to her last Friday or Thursday, and it was the same amount of time she gave me with her paperwork.
I'm that's really not the basis for my,
Okay.
I think that both of you probably need a little more time to work on what Christmas Eve and Christmas Day and the following morning look like. If we check follow winter break for now, but reserve for you all to either kind of meet and confer on that, or bring it in front of the court. Winter break is same as school schedule.
So I think we just have to reserve on both of those sections, Your Honor, until we can come up with something. And also we have to look at the school schedule for 2023, 2024 to see when winter break starts and such. So there's more contemplation that needs to happen here.
I'm going to just put parties reserved to motion hearing. Let's set a deadline. So I'm not going to set a date. I'm not going to put you on a docket, but if you all could note this for motion by, let's say, November 1st, I think that would give folks time to prepare for the holidays. Ms. Anderson, what else can we address for you?
Is it possible to go back and discuss the transportation, because you had ruled on the sports situation last time, and because he has them in sports in Woodland, I will be picking them up and I will be dropping them off because I'll be in Woodland every Saturday for games. So that's
not going to go back and revisit my prior ruling on that. I do recall we had lengthy conversations about what that was going to look like, and this really was a compromise between, I'm not going to keep you, Ms. Anderson, from being where you want to be residentially. You know, me personally, I'm not going to keep you personally from being where you want to be residentially. But because sports are up there, I am leaving intact my ruling on transportation. Again, noting this is a temporary order. And if it doesn't seem to be working as you progress through the next few months, make note of that for your final order.
okay.
Okay.
Anything
else?
I did have
Christmas. And Ms. Anderson, I just want to be clear. So today what you're on is for presentation. I've given you a lot of leeway, but it's not technically a time for you to revisit my rulings, ask for new rulings. This really is a time for us to just clarify some sticking points from our previous hearing and get the temporary order issued. So if you're raising new issues, I'm giving you a little leeway because you're not represented and the petitioner is. But really, if both parties were unrepresented or both parties were represented, I probably wouldn't be giving this kind of leeway. So I need you, if there's a really important point you need me to address today, let's hit it, but otherwise got to move on.
So in the paperwork, she put in there about the relocation that you said that I cannot relocate the kids to school districts, but you did mention the motion I needed to file. So since then I have filed the paperwork. So can we take out the I'm not allowed to move school districts since that hasn't been heard on yet?
No, because this
was heard.
I understand. So where we're at, again, Ms. Anderson, I understand it's difficult to proceed without an attorney, especially when another person is represented. The order I'm signing today does accurately comport with these small changes with my ruling when we were last together and actually had our hearing on this. At that time, I did say I didn't want kiddos moving school districts. This order accurately reflects that ruling. You have since, I see you filed a motion to relocate and move the children's school district. That will be heard by a judicial officer. They can make that decision. Again, this is a temporary parenting plan. It is subject to change, but I am not going to address it today on this docket.
Okay. I think the last thing I wanted to comment on was, yes, it's irrelevant because it's not in the order, but it's about my older son's stuff that's at Dennis's house, and he's being very difficult on letting me get the things, letting my son come pick up his things. I asked him if he could bring his stuff and he's refusing and
Okay,
he's,
so Miss Anderson, does this relate to the entry and presentation of the temporary parenting plan and temporary family law order?
no.
Okay, then I won't be addressing it on this docket. Okay. I also don't have any jurisdiction over the kiddo that's not Mr. Reinerson's.
I just don't know where to proceed with getting his stuff.
Yeah, I can't give you legal advice.
Okay.
Right?
So,
Yes.
Your Honor, are you adopting the temporary order that we prepared? It does reflect essentially that we're entering this parenting plan that we've just corrected those issues on. I just need to know, do you need anything from my office, or were you able to use the magic of whiteout and change what we've discussed here today?
Triple checking now that we've made some changes, and it does not look like we need to make any changes to the temporary order.
Thank you, Your Honor.
Okay. All right. And with the small changes that we've made on the temporary parenting plan, I have initialed. And I'll check that this is a court order. And other than that, I will get this filed with the court clerk now. And Ms. Anderson, Ms. Bash knows this, but Ms. Anderson specifically, you can get a copy of these two orders that I have signed either later today or tomorrow from the Superior Court Clerk's office. Okay.
Okay.
All right. Good luck to you both. Thank you.
Why can't you
Thank
go to
you so
work?
much, Your Honor.
Because you said you can be called up first and then go to work after that.
asked, but they couldn't guarantee me that, so I can't.
Okay. Hey, folks, if you are in the courtroom, I know it's a Zoom courtroom, but if your case is not being called, you have to mute yourselves. It gets too hectic if you're not muted. This is not
I'm
a
sorry.
time for everyone to be chatting.
Sorry about that. Your Honor.
So go ahead and mute. Thank you. Okay. So we are here for minor guardianship docket, August 1st. I have 4 cases on my docket. I'm going to start with one that looks like a set over request. This will be number 4 on our docket. I think Mr. Gooday and Ms. Winkles, you're on this matter.
Yes, that's correct, Your Honor.
Okay. Let me just, and it sounds like, okay, this is one where we do have the emergency minor guardianship in place.
And it is a bit different, Your Honor. We don't
Okay.
have a full minor guardianship trial coming up. Instead, we have the actual adoption finalizing. And so there is a final order going to be entered. It's just going to be in a different case number.
Okay. Help me out here, because my only concern with the emergency minor guardian, it looks like it was originally put into place April 11. Without the full petition, I think I'll be out of time for extensions on August 11th, but please tell me if you understand this differently.
No, I think you're right. So I think in that case, if we can do pending hearing, I will have a full petition in by Friday.
Okay. Mr. Gooday, are you okay with that?
Yeah, Your Honor, that works for me.
Okay. Yeah, I think that's the only way, just in me getting up to speed on these minor guardianship statutes. I think that's the only way I could extend it beyond August 11th. So yes, if one of you can just file the full petition, I will issue an emergency, an amended or extended emergency guardianship pending the date of the full hearing.
Okay.
And then I'll just
Yes, I'll
note,
have that done.
okay, and I'll note full hearing to be determined.
Okay, I will have that, and I'll actually go ahead and put it on the universal trial setting as well. So we do have a full hearing in case the adoption falls through.
That's great. Mr. Gooday, does that work for you?
Yeah, are there any future court dates right now?
So right now I would not, well,
I could
Maybe.
note it. I could note it, Your Honor.
okay,
It's
yeah,
not a problem.
perfect. I'm just going to note for the purposes of the emergency minor guardianship that the parties will note for review if needed prior to the full hearing.
Sounds good.
Thank you.
Okay, and then are there any, I just want to make sure, are there any other parties on that matter that need to be heard?
Your Honor, this is Mallory Smith, the guardian ad litem that have been appointed. I would just inquire of the court whether I would be discharged. My report has been filed. I am in agreement with the guardianship of Ms. Hampton and Mr. Williams.
Okay.
It's absolutely uncontested.
Yes.
I have no objection to discharging the court visitor, and I can have that in the order as well.
Mr. Gooday, any objection?
No, Your Honor, no objection.
Okay, Ms. Smith, I think that makes great sense. Thank you for bringing that up. I will sign that in the order that Ms. Winkles provides. And then I think how I've done this in the past is just state, if we need to recall you for trial, if it went that far, obviously the court would, reappoint for purposes of you being able to bill. I have this on for review hearing regarding visitation and the GAL report. Let me open up my digital file here quickly.
I represent the mother, Monique Barnes, in this matter.
Okay.
And the court visitor is Miss Day.
And I see we have Ms. Day there. Good morning.
Good morning, Your Honor.
So the last time we were together on June 27th, this is when I signed an order appointing our GAL. At that time, I did decline to modify any visitation, kind of pending GAL review. Obviously, I understand that's not a whole lot of time for everything to get done. So I'll turn it over to the parties, maybe Ms. Day first, and let me know where you're at.
Okay. So initially I was appointed as the court visitor, and that was changed to a guardian ad litem at our last hearing. So I've been appointed as the guardian ad litem. I have, since this matter began in March, had almost no contact with the parties. Since our last hearing, I received a phone call from father, which I returned as promptly as possible. I've had no contact with mother. When I called father back, I got no return. So I've not met with either of the parents still. So we are still kind of at this standstill place.
Okay.
I would have the petitioner give kind of an update on how the visits are going. School is going to be starting in just a few weeks. And moving forward, I think that we need to maybe address some of those kinds of concerns, but I'm just at a loss as to what to do. I cannot force the parents to participate, and they just have not.
Yeah, Mr. Anagnosto, you want to weigh in here?
Kind of the same sentiments, Your Honor. I was appointed to represent Monique Barnes. I have had some minimal contact with her. I've been trying to reach her, though, to go forward with this action. I noticed that she is here today, which is good, but I would need to talk to her about going forward.
Ms. Barnes, are you able to unmute and turn your video on?
Yeah.
Yes.
Can you hear me?
Yes, I can. So I'm not going to inquire into any attorney-client privileged information, so I'm just going to talk to you.
Sorry, hold on. I can't hear. 1 second.
Sorry about that, Your Honor.
And do we have a full petition filed, a motion for a full petition filed in this case?
I don't believe it's been filed yet. I believe that the petitioner is working on the full guardianship based on how the emergency has gone. Yes.
Okay.
I think that's in process.
Okay.
And as I'm understanding, we're working off extending the emergency minor guardianship, which was extended to today's date.
Yeah, we did. The original petition I see was approved May 30th. We extended it for the 60 days to today. So what it sounds like I need to do is do my essentially last extension I can do unless we're pending a hearing. So I think for Ms. Levitt, for you to know, I do need before our next hearing that full guardianship petition filed. Otherwise, the statute essentially ties my hands. I don't have a lot of discretion to keep extending the emergency minor. Okay.
Well, they don't have anywhere to live, so.
I understand that. So what I'm saying is I need you to get the full petition in, because as much as I will exercise as much discretion as I can, but I also am bound by the statute. So if there is not a full petition filed, my hands are really tied as to how many times I can continue an emergency order. Okay. Once you file that full petition, I have a little more discretion. Okay. So I want to make sure that's one thing I'm going to ask you to do. I want to go back to Ms. Barnes. Can you hear the court, Ms. Barnes?
Yes.
Okay. So Ms. Barnes, in order for this process to work, two things the court needs from you. One is staying in contact with your attorney. Okay. Do you understand that?
Yes.
Okay. The other thing is staying in contact and responding to the guardian ad litem, Ms. Day. Okay.
Yes.
Those are two very important things, both for you and your case, but also for the well-being of the child so that the court makes the right decision. Okay?
Okay.
Okay. Any questions you have for the court, Ms. Barnes?
No.
Okay. So Mr. Anagnosto and Ms. Day and Ms. Levitt, what I'm inclined to do, given where we're at, is extend this emergency minor guardianship for a second 60-day period. I would set a review hearing 30 days out just to see where we are on that full petition being filed, and essentially Ms. Barnes' compliance with the GAL, et cetera. How does that sound to the parties, especially Ms. Day, Mr. Anagnosto, on behalf of Ms. Barnes?
I think it's imperative that we do have an extension. For the court's information, I will be on vacation starting the 8th of August, and I won't be returning until September 1st.
Okay.
So I have very limited time to see the parties before vacation, or they will have to wait until I return. And then I would ask that I have until at least the end of September to provide information to the court. Hopefully by then I would have information to provide and contact with the parents. But that's,
Okay.
that's for both of the parents. They need to participate.
Yeah. Is Mr. Raymond on?
Mr. Lewis.
Oh, Mr. Lewis.
Yeah,
Thank
yeah,
you.
yeah.
I was looking at your middle name. Thank you. Mr. Lewis, kind of same goes for you. Your active participation with the GAL is vital to the court making the right decision.
My audio just came back in.
Okay. Did you hear what I
didn't-
said?
I didn't hear what you said,
Okay.
and it was on this day when it went out.
Okay. So what I'm saying is that just like I said to Ms. Barnes, your cooperation and contact with Ms. Day really is imperative to the court ultimately making the right decision in this case. Okay.
Understandable.
Okay. So Ms. Day, remind me I will extend the minor guardianship another 60 days. What would work for you, Ms. Day, for a review date before that 60-day expiration, if anything? And I don't care if it's exactly 30 days or 45.
If we could go out to the 19th, I would be able to have information to the court by then. That will give me time to hopefully meet with both the parents, even potentially observe a visit if possible. Again, because of my vacation, that kind of limits my time, but I will do my best to make sure to get something put together that says what the efforts have been on everybody's part, hopefully
Okay.
positively.
Understood. Mr. Anagnosto, does September 19th at 10:30 work for you?
Yes, that works for me. Is that fall judicial conference?
Oh, is it? Yeah, it is. Will we be doing this docket?
No,
No.
on the Thursday we would be, so the 21st.
Okay.
Then can we go out to the 26th?
Yeah, let's just to be safe. Yeah. So thank you, Mr. Anagnosto. The court did confirm that. So it will be September 26th at 10:30. Will that work for the parties?
Yes.
Then it works for me, Your Honor.
Okay. And then Ms. Barnes and Mr. Lewis, what that means is our next court date on Zoom will be September 26th at 10:30 a.m.
Yes, that's fine.
Okay.
And my understanding is the parents are getting visitation. I don't think there's any formal order, and I'm not sure if we need one or if we want to discuss that at this point.
I believe there is a formal order from the prior hearing.
Okay.
Okay. Let me just look here. When I did
I think it was from the May 30th, Your Honor, prior to
yeah,
your-
and I did circle visitation on my extension order, and I said, okay, thank you, Ms. Day. I do see that. It says the parents' visitation shall be as follows, and I said, see bench order May 30th. So let me go there, make sure we have everything covered. The bench order regarding visitation from Commissioner Nelson is still the visitation with the minor every Saturday from 10 a.m. to 4 p.m., every Wednesday, 5 p.m. to 7 p.m., or at other times as agreed to by the parties. In addition, the parents may have unlimited Zoom and telephone contact with the minor. Is that working okay for the parties for the time being?
Your Honor, if I may, every single phone call that I have with my son within 30 seconds, sometimes like within 5 minutes, my mom is saying, okay, hang up with dad, tell dad goodbye. So, I mean, it's being like every single time. It's like, I can't talk to my son for 2 minutes without her going, okay, tell dad goodbye, tell dad goodbye.
Okay.
We were supposed to have unlimited time, right?
It does state, so Ms. Levitt, I guess I would just say that, you know, the order from the prior judicial officer is there really are no limits on the Zoom and telephone calls. Obviously, parties, please use your best discretion. This should not be something that's taking up the day and interfering with the child's activities with the guardian and that sort of thing. But Ms. Levitt, I do think it is realistic to allow those to happen for more than, you know, a minute to 5 minutes. Okay. I can't hear you, Ms. Levitt, but I think you agreed with that. Just give me a thumbs up. Okay. Yeah, I just don't have audio from you. Okay. So we can, I'll just make a note that we can kind of check in on whether the telephone visitation is going better when we get together in September. Okay. And then Ms. Levitt, your homework really is to get that full guardianship filed. Okay. Otherwise, my hands are going to be a little tied once we hit our next review date. Okay. Okay. All right. Anything else from the parties on this matter?
No, Your Honor.
No, you're
Okay. All right. Thank you all. So Ms. Barnes, Mr. Lewis, Ms. Levitt, you are free to log out.
Your Honor, and my client is present.
Thank you.
Okay.
Thank you.
Jump into that file here. So what I am showing, this is one where we do have a full petition filed. Is that correct?
That is correct, Your Honor. Last we were here, there was an issue of service on the father of Mr. Joel Showden. It was unsure of his location. So far, we have done the order to serve by publication that was signed on July 11th. Currently, the notice to serve is running for 6 weeks in the Courier Herald. That was done immediately after, I believe, on July 11th. It has been in the paper the last 2 weeks. It will be running every Friday for 6 weeks. It runs every Friday until August 25th. Ms. Ford, for the record, Mr. DePriest did go and he was able to obtain Odin's birth certificate, and Mr. Showden is listed as the father on the birth certificate. So the publication by alternate means or service by publication was necessary in this case. And I'd also like, I do not know if Mr. Anagnosti's client, Ms. Melissa Howard, has appeared or done anything besides her objection originally in this case, but I'd like the court to note that on July 11th, the same day the order was signed, I did provide Mr. Anagnosti and Ms. Day the most recent phone number my client has for Ms. Howard, as well as a list of her upcoming court dates that were provided by Mr. DePriest, his criminal court dates. So we are currently still asking the court to extend the guardianship and to set a new hearing until either Mr. Showden, Joel Showden appears, or until the time runs on the publication. Mr. Anagnosto.
Yes, Your Honor. I am playing phone tag with my client. She has called in to my office a couple occasions. I've attempted to call back. My staff has attempted to set times, but unfortunately, I have not been able to speak with her. She did file an objection, and my position at this point is that she objects to the guardianship. She filed a formal objection. I don't have any further instructions other than she is periodically attempting to contact me, and I'm trying to contact her.
Okay, thank you. I appreciate that. Ms. Day, I believe, are you still on this case? Just double checking.
No, Your Honor, I was
Okay.
relieved as the court visitor. My understanding would be that if it was necessary when the full guardianship, then I could be reappointed if that was necessary, but that just depends on how things go moving forward.
Gotcha. Thank you. I appreciate that. And I anticipate once we get the service issue resolved on that full petition, then we will reappoint you GAL on that. So thank you for being here. So it sounds to me, and folks, correct me if I'm wrong, but the full petition has been filed. That the service has been made on the mother. We need to wait out essentially the service by publication on the father. But at this point, I think in my discretion, because a full petition has been filed, although this has been going on for some time, I would be comfortable doing an extension of the emergency guardianship. I think our last order Ms. Holder, that you did fill out indicated that is ordered until the final hearing is held on the minor guardianship. So I think
Yes, Your Honor.
we would simply continue with that. We would just need to issue a new order with whatever our next hearing date is in this matter. Does that make sense to the parties?
Yes, Your Honor, it does.
Okay. And you're saying 6 weeks from what date?
It was six weeks. I believe the first publication was immediately after the 11th of July. So the publication is running every Friday. So once a week on Fridays through August 25th. And then in August 25th will be the last date that it runs.
Okay. So would Ms. Holder and Mr. Anagnosio, would you two be available for the August 29th docket at 10:30? That would be the first Tuesday after that last publication.
Yes, Your Honor.
And then Ms. Holder, would you be willing to circulate an order to that effect? I think in all other respects, mirroring what you submitted last time, but changing the hearing date and the issuance of the letters through August 29th at 10:30. The digital file.
Yes, Your Honor.
Okay, great.
This
I will
is
sign
one
that
where,
once received. I don't think I have seen this case yet, since I have been on minor guardianship docket. So what I'm seeing in kind of getting up to speed here, and I'll please, Ms. Farr, Ms. Anagnosio, Mr. Anagnosio, excuse me, Ms. Woodruff, please correct me if my understanding is wrong. But what I'm noting from the last time you all were in front of a judicial officer in June is that essentially we're in an immediate emergency guardianship order. We've had some continuances, many continuances kind of along the way. So I'll let the parties jump in and tell me where we're at and where we need to go.
So, Your Honor, just to give you a brief summary, so both petitions, the emergency and the standard, have been filed.
Okay.
Dad has not appeared or responded. Both parents have been served. I don't believe mom has filed a formal response or objection yet either, but she has been appointed an attorney. The certificates of training have been filed. The disclosures have been filed. I have talked with Ms. Woodruff. I have met Shyla. I have viewed the home. The last hearing was to give me some time to meet with mother because several months have gone by and I hadn't met with either parent. I did meet with mother for a very brief meeting and her phone died. And then she has not been in contact with me after. I just learned this morning that she spent the last month in Hawaii on vacation. And so that's probably why I haven't had any word from her, but we're still in the immediate order and we do probably need to get the emergency order put in place. I'm not sure what Your Honor wants to do, but I can get my report in this week. And if we want to set this out for 1 week so we can appoint the emergency guardian next week, that would be my suggestion. And then set it for hearing unless mother is going to consent.
Right. Mr. Anagnosio.
I haven't had contact with my client since the last hearing and would need an opportunity to speak with her about what she is requesting at this point. It's my understanding that she lives locally and was getting some visitation, but I'm not sure what the status of that is at this point.
So the visitation that was occurring was only occurring along with the younger child who was in a dependency action, and there's been that child is being adopted by Miss Woodruff. And so that child has specific visitation times, and Shyla was going along with that, but there's nothing formal. There isn't any kind of a formal visitation schedule in place.
I think what I am inclined to do, and Mr. Anagnosio, based on your statement, 2 weeks might be more appropriate, but what I would recommend is that we set this for the show cause hearing on issuing or not the emergency minor guardianship order. I know Ms. Farr had mentioned next Tuesday. If you feel like you'd be ready, great. if you want until August 15th, I am open to that as well. So you guys let me know what date works best.
I think I would prefer at this point, next week.
Okay.
To have this matter resolved one way or the other sooner than later.
Right. I think that makes sense. So as long as we're not, I know Ms. Farr, that puts a time constraint on you as well. But I think that makes a lot of sense in this case. Ms. Rapp, you are represented by your attorney, Mr. Anagnosto here. So much like I've said to other folks, and can you just give me some indication, Ms. Rapp, that you can hear the court?
I hear you.
Okay. So please, in the best interest of your case, your child's well-being and the court making the right decision, please stay in contact with your lawyer and please have contact with Ms. Farr, who will be making recommendations to the court. Okay.
Okay.
Okay. We will be back on, I will extend the immediate order. I'll get that done this morning through August 8, next Tuesday at 10:30 a.m. On that date, we will move forward on a hearing unless it's an agreed order, but otherwise a hearing on the emergency order.
Right.
Okay. Okay.
Thank you, Your Honor.
Thank you. Anything else from the parties? Ms. Woodruff, I know we have you muted. Thumbs up that you're good with that date. Okay. All right. Sounds good. Well, thank you all. That takes care of my docket. We'll go ahead and end this Zoom and see some of you back next week.